9-0 Supreme Court ruling in Donald Trump's favor is where we have to begin.
Donald Trump.
The breaking news, the Supreme Court has ruled that former President Donald Trump should appear on the ballot in Colorado.
The Supreme Court ruled that states cannot kick former President Donald Trump off their ballot.
The Supreme Court just made a decision that both Democrats and Republicans are talking about because it has an effect on the next election. If you like this content and want more people to see it, one of the best ways to help is to like and subscribe.
So I just want to thank all of you for being here. I think it's a very big day for America. I think it's a very big day for liberty, and I think it's just a great day for this country.
It was announced in the beginning of the video that we would be discussing a 9-0 decision made by the US Supreme Court today. This decision says whether Trump can run for president in this election and whether a state like Colorado can disqualify someone like Trump. Now, this case doesn't directly involve the Second Amendment, but this decision will have a big effect on many things. For people who support the Second Amendment, it affects a lot of things besides just the election. We need to be able to pick who gets elected. We need someone who will speak out for the Second Amendment. To be honest, I have a lot of problems with Trump. I don't believe he's the best person for the job. I have my own thoughts and feelings about him. Don't forget that he's the one who caused the bump stock problem. Those were the days when he pushed for the ATF to regulate bump stocks. That has led to a lot of other problems with the ATF going too far, like the pistol brace problem, unfinished frames and receivers, and so on. And Trump was the direct cause of that. To be fair though, he was also in support of the Second Amendment in other ways. For example, he made sure that the Supreme Court had justices who supported it, which led to the important decision in New York State Rifle and Pistol Association versus Bruin. Along with that, he has helped to change the makeup of a number of other lower courts and circuit courts, such as the Ninth Circuit. That's a lot of pros and cons. However, I believe he is much more supportive of the Second Amendment than, say, Vice President Biden. It's likely that some people want to vote for Trump instead of Biden. Because of this, it's important, and not just for the two-way cause. They are also important for many other reasons. The case we'll be breaking down and talking about is Trump vs. Anderson, which was just decided by the Supreme Court. The state of Colorado tried to keep Trump from running for office based on Section 3 of the 14th Amendment, which led to this case. Some voters in Colorado say that Trump can't be president because of Section 3 of the 14th Amendment. Once more, the Colorado Supreme Court that looked at this case agreed with that point of view. Therefore, the Colorado Supreme Court told the state's Secretary of State to take Trump off the Republican primary ballot in Colorado and to throw out any R and votes that were cast in Colorado for President Trump. The Colorado State Supreme Court did put a hold on the decision and its implementation until the US Supreme Court looked into the case and made a decision. What this case was about was whether Section 3 of the 14th Amendment could be used in Colorado and maybe other states to keep Trump from running for office this year. And after thinking about it again, the US Supreme Court decided today by a vote of 9-0 that Colorado and other states cannot do this kind of thing. That means that the court as a whole and unanimously decided that what the state of Colorado did was indeed against the Constitution. Even the more liberal judges agreed with this point of view, and in the end, the basic judgment and overturning of the Colorado State Supreme Court's decision were the same. That's why the vote was 9-0. That's because Section 3 of the Constitution says that Congress, not the states, is in charge of enforcing it against people who hold federal office or run for office. That's what the Supreme Court said in general. So, that decision from below was overturned by the court. Yes, there are some bad things that will happen, even though a lot of the news will talk about how this was a 9-0 decision. That's not always how the Supreme Court works, you know. There were a lot of problems with this decision that came from the different points of view. Yes, I did say it was a 9-0 decision, but there were still some judges who didn't agree with the majority's decision on one part of the case. 4 of the justices said the same thing, 1 in agreement and the other 3 in disagreement. In the end, they said that the majority of the Supreme Court went too far with this decision. But for people who are new to Supreme Court cases, this is an example of a per curiam ruling, which means that the majority opinion was not written by a specific justice. Most of the time, if there is a majority opinion, there is one author, like Justice Thomas, who writes for the majority. But as you know, this was written in a per curiam, which means that no specific judge was named as the author of the opinion. It's just the court's opinion. Probably because this is so politically charged, they don't want one justice to write it. Instead, it's an opinion written by the court as a whole. As I said, what's interesting about this decision is that all 9 justices agreed on what the final decision would be. They all agree that what they did was not legal in Colorado. In the opinion, they all said that Congress, not the states, is responsible for enforcing Section 3 against people in federal office and candidates for office. So, they went against what they had decided before. All 9 judges agree on the following as their main point of view. All of them said that this case makes them wonder if Section 3 can be enforced by the states as well as by Congress. We've come to the conclusion that states can disqualify people who are running for or already hold state office, but the Constitution doesn't give states the power to enforce Section 3 when it comes to federal offices, especially the presidency. In this part, the court said that Section 3 of the Constitution does not give the states any power to enforce it against people already in office or running for office at the federal level. Not even the respondents say that the Constitution gives states the power to get rid of federal officials who are already in office and may be breaking Section 3. In the opinion, they also say that the respondents still say that states can use Section 3 against candidates for federal office, but that the text of the 14th Amendment does not explicitly give the states that power. The amendment's language only talks about how it will be enforced by Congress. Section 5 says that Congress has the power to enforce the amendment through legislation. All of this comes down to the fact that Section 3 of the 14th Amendment says that only Congress can remove federal officials or make laws that do not allow them to serve. That's not something a state can do. That's not possible. While there is a 9-0 vote for a reversal, there is no 9-0 vote for the way that reversal was done. In fact, 5 of the judges did more than just that. Justices Thomas, Gorsuch, Kavanaugh, and Roberts seemed to be part of the 5-judge panel that wanted to go a little further and give more information about the decision. They wanted to know more about how a judge can be removed by Congress and what kind of laws would need to be passed in order to do that, so they went a little further. It was the liberal judges and Amy Coney Barrett who wrote a concurrence saying that they did not agree with the 5 majority. They went a little further with their decision. We were a little worried about Justice Barrett going into other cases. She did write a concurrence in which she expressed her anger at the 5 other justices' opinion and said she would only agree with certain parts of the decision. I joined parts 1 and 2b of the court's opinion, she said. I agree that states don't have the power to punish presidential candidates under Section 3. That principle alone is enough to settle this case, and that's all I would say. Voters in Colorado filed this suit in state court, as required by state law. It is not necessary for us to answer the difficult question of whether federal law is the only way that Section 3 can be enforced. Since the majority chose a different path, the justices who are still on the bench can decide how to respond. I don't think this is the right time to make your disagreements louder and stronger. As the election season for president is in full swing, the court has settled a politically charged case. Writings on the court should bring down the national temperature, not raise it, especially in this case. Right now, the fact that we all agree is much more important than the fact that we disagree. The 9 justices all agree on how this case should end. That's the message people in the US should remember. It sounds like Justice Barrett is very worried about the political chaos that this decision could cause. In her concurrence, She's trying to say what she doesn't agree with about what the majority did, which is that they might not have gone as far as they did in overturning the Colorado law. She's trying to calm things down and say, hey, we shouldn't be fighting on the Supreme Court. Let's just issue something that's a little bit more neutral. Finally, this anger can be seen in the speeches of Mayor Kagan and Jackson, who are the liberal justices. In their dissent, they say that today the court goes against an important principle that will affect not only this case, but also future challenges. The court has to decide if Colorado can keep a presidential candidate off the ballot and from running for federal office under Section 3 of the 14th Amendment. We all agree that letting Colorado do this would create a patchwork of laws that are inconsistent with the federalism principles of our country. That is enough to settle this case, but the majority goes even further. Even though all 9 members of the court agree that this is an independent and sufficient 5 justices, then make decisions on new constitutional questions that will keep this court and petitioner out of future trouble, even though that problem only involves one state's action. In this case, the majority thinks about who in the federal government can enforce Section 3 and how they must do it. What does this mean? First, let's go over it again. All 9 justices agree with the rule. In the end, they all agree on one thing. Colorado does not have the power to remove or disqualify someone from federal office. In other words, stop someone from running for office. This part of the Constitution says that the states don't have that power. Because of this, what Colorado said is being thrown out, and they're going against what the Colorado State Supreme Court said. And that's pretty much the ruling. There are going to be some disagreements because some judges think that the other 5 Supreme Court judges should have stopped the decision there. They did not need to go any further. But I really think that the 5 judges on the Supreme Court did that to try to stop some of these actions from happening again, especially this year since there are elections. There will be a lot of disagreement when you read the news that the Supreme Court ruled unanimously. You might hear some other things too. Yes, the final judgment was made by a vote of 9-0. A lot of people still disagree and fight with each other about how they came to that conclusion though. So I hope you got some information and ideas about that choice. If you have any questions, please leave a comment below and I'll do my best to answer them. Don't forget to like and subscribe. And remember that this is Chong with Bill B Scholars, and this country will be kept up by B Scholars.